Hi, this is Attorney Alan Levine with the Law Office of Alan J. Levine, also known as Georgia DUI and Criminal Defense. I'm doing this video today about a new proposed law, H.R. 875, that just came out of our Judiciary Committee in the U.S. House of Representatives, and it's now presumably going to the floor for a vote, up or down. At which point, if it goes further, then it would go to the Senate to be considered. And if it makes it past the Senate, then it would go to the president's desk for signing. But the point of this bill is it makes it such that aliens, in other words, people who are not citizens, they're not citizens by birth in the United States or naturalized citizens, those people, whether they're here legally or illegally, here on student visas or on work visas, whatever, if they commit the act of driving under the influence, those people would be either deportable or inadmissible. Now, I'm not an immigration attorney, but as a criminal defense attorney, I need to be and should be up on immigration law at least a little bit. Nevertheless, what I do when I do have a client who has potential immigration issues and we're trying to figure out how should we handle their case, I still advise them to go ahead and get an immigration lawyer as well. This law, what it does is if it passes as written, it would make it a deportable offense to commit a DUI. It would also make that person, the alien, inadmissible if they commit a DUI. Well, let's focus first on the deportable part. Under this act, and I'll post a link to the act itself so you can read it for yourself. But what it essentially does is, if you are convicted of a DUI, you will be deportable. So out of the country, you'll have to leave. Now, how that will actually be enforced, will you in fact be deported? I don't know. Right now, as it stands, committing a DUI without more, just a person who goes and has a couple glasses of wine with dinner, they get pulled over because maybe they failed to maintain lane a little bit, not too much, but their tires drove over the center line just a little bit, but no accidents, and the officer pulls them over. And there's the smell of alcohol on their breath, at least the officer says there was. And there should be if they had a couple glasses of wine, right? That's not unreasonable to think that maybe there was a little bit of odor of alcohol. And then they go ahead and they do the field sobriety test, and of course they don't pass. They never, very seldom do, right? Step off the line while they're doing their 9-step test, and they're arrested for a DUI, and they plead guilty to a DUI, and that's it. Well, right now that is not a deportable offense. You will not get deported for that DUI, okay? But that could change. All right. Now, if you're an habitual DUI offender, where you've had several DUIs, or somebody has been seriously injured or killed because an alien committed an offensive DUI, that could conceivably be construed as a crime of moral turpitude. And if you do commit a crime of moral turpitude, then you are at that point deportable as well. But this is going to be a much more sweeping. It's going to cast a broader net. It's going to be a much more all-encompassing law, which will now make any DUI, no matter how trivial, a deportable offense. So, and then the big concern for me as a DUI attorney is, okay, not only does that mean that I much more likely will need to, if I can't get a better deal negotiated for my client, get the charge reduced, then we'll have to go to trial, and we'll have to fight a lot harder all along the way. But I also have concern for past clients who may have pled to a DUI, because now, there's something called an ex post facto prohibition. It's a constitutional prohibition that if the state or the government makes a law that all of a sudden prohibits something. Well, let's take it for instance. Let's take a silly example. I make my own dry rub for my chicken wings, okay? And I use habanero in it, all right? Let's just say that tomorrow the federal or state government makes a law that says habanero use is illegal. Well, they can't go back in time and arrest me and convict me for my past use of habanero, okay? But in the future, after the date of the law being passed, after that, I can't use habanero legally. If I'm caught, I could be arrested and prosecuted. To go back, however, in time before the law against habanero was passed would be an ex post facto prohibition. I cannot be convicted. I can't be arrested or convicted for that prior use of habanero. And that's, of course, presuming that it's part of the criminal code, okay? You can't have ex post facto crimes. But the immigration status of a person is a civil matter. And furthermore, the law doesn't make a new prohibition against DUIs. It's never been legal to drive under the influence of alcohol. It's illegal in every state, and it's also illegal according to federal statutes. Again, I don't practice a whole lot of federal law, but you can't drive intoxicated in the national parks either. Okay, so this law is not making anything new, a new prohibition or creating a new offense. It's simply saying it's basically just recategorizing your status as an immigrant and saying, okay, and if you commit DUI or did commit a DUI, if you got a DUI in your record, you're now deportable. So could the government go and find people who've been convicted of DUIs in the past and then deport them? Potentially. Now, how will the courts address that? And the answer is well, it depends. We don't know. Currently, the way the law is written, there is nothing explicit one way or the other about how the Congress wants to deal with prior DUIs. There's no grandfather clause, no grace period that says if you committed any DUIs committed before this date, this bill is made into a law, any DUIs committed prior to that will not be deportable. It doesn't say that, nor does it say that they are explicitly deportable. It seems to me they're probably purposely not addressing that issue, okay? And maybe they're going to leave it up to the courts to decide. And then maybe it'll be a basic fairness issue where the courts simply say, well, since you guys didn't say, the Congress didn't say what your intent was, it wouldn't be fair to deport people who had prior DUI convictions. But the courts could go the other direction too. We just don't know. And I'm going to be looking more into that issue as well as I try to formulate my ideas about how different courts and different judges might go, because ultimately this could end up in the U.S. Supreme Court. Who knows? Who knows? And how many years will it take to get there? Who knows? Okay. In either way, in any case, it is certainly going to make for a lot of contentious issues in the future. Now, as far as admissibility goes, or inadmissibility, if you are not in the country yet, there the law has proposed under H.R. 875 is a little broader. It's not just if you were convicted of a DUI in, say, Canada or in Spain or whatever country you live in, but if you admit to facts that would support a DUI conviction, that also will make you inadmissible. Okay, now, how will they practically get the record? Will they go to the trouble of looking at the record of a plea that occurred in a different country to say, hey, wait a second, you admitted to facts here that support a DUI, even though you didn't actually plead to a DUI? I don't know. Maybe not. But nevertheless, under the law as written, it would still make you inadmissible. And as a more practical consideration, maybe a little more realistic, what if you're an attorney and you're representing a client who is not here, they're not a citizen, okay? Maybe not legally, illegally, who knows? Maybe they're here again on a student or work visa, okay? And you work out a reduction to that case, okay? A lot of times what the defense attorney is trying to do for their client is get the DUI reduced, say, from the DUI itself down to a lesser charge. In Georgia, we have, for instance, what's called reckless driving. Okay, reckless driving is still serious, but not as severe as a DUI. You don't have the license suspension considerations, whereas in Georgia, a DUI must be a 1-year sentence, could be on probation, might even be on non-reporting probation, but it has to be a 1-year sentence. You get it reduced to reckless, and at that point, maybe you only negotiate a 6-month sentence or a 3-month sentence, or maybe your client's done everything that the state wanted already, like defensive driving, and got a drug and alcohol assessment and did some AA classes. And based on that and the payment of a fine, the court is satisfied that the person has learned their lesson. They plead to the reckless, and the case is over. It's closed. Well, in Georgia, no. If it's a DUI, it's got to be a 1-year sentence regardless. Okay. So you try to get that reduced down to a reckless, and maybe get even reduced further down to just failing to maintain lane, or maybe it was an expired tag that led to the stop. Who knows? You get it reduced, though, either way, to a lesser charge. Well, if you're here in front of the judge, a lot of times what happens is during the plea, the prosecutor reads off a list of facts, and they say that, client so-and-so committed the offense of failing to maintain lane 3 times. The officer noticed it, pulled him over, noticed the odor of alcohol. The client had red bloodshot eyes, had trouble getting out of the car. They agreed to take the field sobriety test, and of course those tests never go well, seldom anyway. They do the eye test, and 6 out of 6 clues on the little test where the officer's doing this back and forth in front of the client's eyes. And of course, it's always 6 out of 6 clues typically. And they can't, walk the line back and forth, 9 steps back and forth. They stumble on that, and you see it on video too, maybe. And the prosecutor states all this stuff, and then they turn to the defense attorney and they say, "Do you agree to those facts?" And for the most part, you say that's basically the gist of it. Okay. Well, if that's on the record now, if that's established on the record as the basis of a reduced plea, and then your client leaves the country for, whatever reason, to visit family, on business, who knows why, they leave the country, and then they seek to come back in. Well, I don't know if it's going to actually happen as a practical matter, but at this point now, if you have on the court record facts that establish a DUI, even if the charge was reduced, if that's found out and the government was energetic enough and diligent enough to look at that, that could prevent your client from coming back in if they weren't a citizen. They'd be now inadmissible. At least that's my position on this. Again, it may be, straining at gnats and swallowing camels to worry about it, but I think, as a defense attorney, I'm naturally a glass is half empty person, and I'm always thinking about the worst case scenario. My take on this is that if I work out an agreement for a client to take a plea on a reduced charge, and immigration issues are possibly going to be an issue based on this law if it passes as written, we'll stipulate to facts that support the plea, but I don't want any facts read into the record. I mean, you have to stipulate to something. The judge would not be doing their job if they just took a plea without any facts at least being stipulated to, that, we state on the record that, yes, Judge, there is a factual basis for this plea. But then the problem is going to be with what happens when the judge wants more on the record, because they themselves don't want to be taking pleas from innocent people. They want to know that the person in front of them is in fact guilty of something. And they may want to know, well, why is this case being reduced? The judge may want to dig into this. And so that I, as a defense attorney, probably am going to want to approach the judge with the prosecutor ahead of time and alert the judge that, look, we've got potential immigration issues, and so I don't want to get into key facts on the record in this plea. And then we'll see how that goes, because some judges may not be okay with that, and some judges may be. So, and some prosecutors may have problems with that, and so it's gonna make for some interesting issues. At any rate, that's what this new law purports to do. If you commit a DUI, you're deportable. If you're convicted of a DUI, in other words, by either after a trial and you're convicted, or if you plead to a DUI, you're now deportable. And if you are convicted of a DUI, or if you admit to facts that would support a DUI, you're inadmissible. Okay, and again, it's whether would it support a DUI or be a DUI in the jurisdiction where the conviction occurs. Okay, so if we're talking about like inadmissibility, if you are in a foreign nation that has laws, say, similar to the U.S. as far as driving goes, if you admit to facts that would support a DUI in that jurisdiction, and then you want to come into the United States, you would be inadmissible. I don't think there's anything else to really discuss about this just yet. I think it's going to be very, very interesting to see how this progresses. Like I said, it made it out of the House Judiciary Committee. If I didn't already state, it was introduced, I believe, on January 31st by Representative Barry Moore, Republican out of Alabama. It's now out of the House Judiciary Committee. My understanding is that most bills do not actually make it into law. Most bills just die somewhere, and even most bills that do make it into law oftentimes take years to get through the House, through the Senate, before they finally get to the president's desk for a signature. That being said, if I was to read the tea leaves here, and I'll go ahead and read the tea leaves. I'll go ahead and read the chicken entrails. I think I'm more confident about this prediction than I am about my March Madness bracket. I think given the political environment as it stands now, and given the fact that the Republicans have the majority in the House and the Senate, and given this administration and their positions on immigration, I think this bill will progress relatively fast. I simply would not be surprised if by the end of summer, early fall, that this bill's not up for signing by the president. And we'll just see how it goes. Will it be amended to put in a grandfather clause or grace period for DUIs that were committed before the bill, or will it just leave it an open question, or will it be explicit and say no, this encompasses everybody, no matter when your DUI was committed? That'll be interesting to see. So at any rate, again, this is Alan Levine with Georgia DUI and Criminal Defense. Thank you for listening. And if you have any thoughts yourself, you have any considerations, or you think I got something wrong because you yourself know far more about immigration law than I do, or criminal law than I do, please feel free to post those in the comment section below. And last caveat: this is not intended to give legal advice, so please don't rely on anything I say for your own particular legal case. If you do in fact have a legal case with either criminal or immigration issues, please get an attorney. Please get an attorney that practices in the jurisdiction where your case is. Thank you for listening, and take care.